Hi, this is Erin Lacey. Good afternoon if you're on the East Coast, and good morning if you're out west. Let's start off the top here. You're listening to the proposed borrower defense regulation. This is a webinar that's being offered by Thompson Coburn LLP. We're a law firm, and our higher education practice in particular is offering this particular, we'll call it a special webinar because it's not part of our typical, our upcoming higher ed webinar series or any of our typical series. I wanted to start with some housekeeping, as we often do. The very first thing I want to note is that this program is not, let me repeat, this program is not certified for continuing legal education. That's unusual. Every program that we've done since I have been here in the last 5 years has been, and we typically try hard to do that. Because this was a special presentation done very quickly, we didn't have the runway to get it CLE certified. So my apologies to the attorneys on the line or the folks who may have been tuning in particular for CLE. Our higher education webinar series, which is coming up and starting very soon and will go through next year, all of those will be CLE certified, and we would expect that typically all of our webinars will be as they have been in the past. This webinar is timed to last approximately 90 minutes. Also, please remember that if you're listening to this at some time after the original air date, meaning today, it is possible that law and guidance has changed. Actually, because this is about a proposed rule, obviously, we hope to see a final rule in the coming months. Okay, so let's get started. My name is Erin Lacey. I am a partner here in the higher education practice. For those of you who tune in regularly, you probably know who I am fairly well by now because I do a lot of these presentations myself. Our higher ed practice at the firm, and this sort of gives you a read on what I do personally as well, we provide regulatory counsel to institutions of higher education on all that higher ed stuff, the federal, state, and accrediting agency laws and standards, Title IV federal financial aid programs, Title IX, Clarity Act, etc. We help schools with all kinds of transactions, whether that be contract drafting, negotiation, policy creation, different kinds of agreements, articulation agreements, vendor agreements, etc., and compliance systems design. We also do merger and acquisition work, both for for-profit and nonprofit institutions. And we represent schools in student-employee litigation. We do government investigations and lots of administrative proceedings, so like Department of Ed program reviews, IG investigations, and things like a borrower defense action. Okay, just quickly so you know, before I was here, I did spend some time in-house, 4 years, with a fairly large decentralized school group and got a lot of experience sort of on the other side. And I was in-house between 2010 and 2014 when a lot of the earlier versions of these rules and regulations were coming along are being dealt with. So I do have a real appreciation for what it's like to be on the other end of the line. Let's talk first about the scope of the proposed rule. And for those of you who've listened in to some of my prior webinars on the borrower defense rule, I am going to do just a little bit of background here, but I promise it won't be too much. I just want to make sure we all have some context before we launch into this proposed rule. By the way, I noticed today, I think this is our 12th webinar on this platform on the borrower defense rules, so we may be going for a record. We call it the borrower defense rule, but it covers a number of subjects, and I'm going to hit on all of this today. The borrower defense framework, which we'll talk about first, is certainly the headliner. But in addition, this rule includes important provisions relating to financial responsibility, closed school discharge, false certification discharge, and arbitration agreements. So we're going to touch on all of that. My real goal here today is twofold. One is to provide you all with information and education regarding what the U.S. Department of Education is proposing, but also it's very important, I'm going to try to give you some recommendations on things you might consider for potential comment. We have less than 30 days right now for schools to comment. This is a very important rule. There are parts of it that I think schools will want to support. And there are parts where you might seek revision, and it is equally important that you comment and let the department know both that you like what they're doing and maybe you don't like what they're doing, but you have 30 days to do it. The other thing I'll highlight is it's really easy to do. All you have to do, you can put together an email, you can write a quick Word document, and you can submit it electronically. It's just the click of a button, so it's not procedurally a hard thing to accomplish. Okay. So let's focus first on borrower defense. Again, that's the headliner. Let me just give you a little bit of the origin story so you know where we're going with the proposed rule. In 1993, Congress created the direct loan program, right? So we all get all our students get federal financial aid now through direct loans. And as part of that legislation, Congress said, we want the Department of Ed to specify which acts or omissions of an institution of higher ed a borrower could assert as a defense to repayment. So in other words, you've got a borrower who's got a loan, the U.S. Department of Education says, hey, you owe us money on that loan, you're not paying it back, and as a defense, the borrower says, I shouldn't have to pay it back because my school did X, Y, or Z. So basically, Congress told the department, you need to articulate what X, Y, and Z might be. The following year, the department did that. So way back in '94, they created the very first borrower defense regulation. And it's a pretty simple affair. And they said, look, if your school does something that would give rise to a cause of action under applicable state law, then that could be the basis for a borrower defense claim, right? And we're going to talk a little bit later why that's been very complicated. Subsequently, it turned out that's a hard standard for the Department of Ed to administer, because when they have a claim, one of the things they have to do is go investigate and determine whether or not whatever the student or borrower says that the school did, in fact, violates some applicable state law. Of course, the U.S. Department of Education isn't necessarily expert on all the state laws in all 50 states, so that's been problematic for them. But and this is still the current standard. Under current law and since 1994, the question has been, did the act or omission give rise to a cause of action under state law? At the same time, the department created a fairly basic process. You would have the department initiating a collection proceeding, and then the borrower would assert the claim. The department would consider the defense, and then the department could forgive all or a portion of the student's loans. Three important points here. One is the department has always and continues to maintain the position that it can offer partial relief. So if a student has $30,000 in loans, the department maintains we can give relief in any amount. It could be $5, it could be all $30,000, right? The other thing that's really important to keep in mind is that there's a distinction here between the discharge proceeding and a recovery action. So you see this last box. It says the department then has 3 years to initiate a separate action to recover that forgiven amount from the institution. And this is also why, for schools, this is such a critical rule. Not only does the department have the authority to discharge the student's loan, but then the department maintains that it has the authority to turn around and recover any amount that is discharged from the school that committed the act or omission, right? But those are different proceedings, and they've always been different proceedings. Conceptually, this has always been envisioned as two parts. One is the discharge decision, and the other is the recovery action. And as we'll see in the proposed rule, the department continues to maintain that idea that you would have a first decision that would be made and then subsequently a recovery action against the institution. Okay, in '95, there was a little additional information the department provided. They indicated that, you know, the cause of action under state law can't just be anything. It can't be a slip or fall. It's got to relate directly to the loan or the school's provision of educational services. And the department said at that time, you know, personal injury, tort claims based on sexual or racial harassment, for example, would not be included. There are other avenues that certainly a borrower could seek to address those types of issues, but they're not the basis for a borrower defense claim. They also acknowledged at that point in time that while there wasn't any sort of formal set of procedures protecting a school's ability to be involved in the discharge process, the department did acknowledge that schools were entitled to due process, at least in the recovery action proceedings. So for 2 decades, this framework was more or less sufficient. Right, so from 92, 3, 4, 5, in that range, all the way up until really 2015, there were just a handful of borrower defense claims. I've heard different numbers, but usually it's single digits that people suggest were ever filed. Then Corinthian collapsed out on the West Coast, and there were a couple of other large school failures or issues where large school chains were challenged. And at the same time, there was a lot of heightened attention to the cost of education and also misconduct among schools. And all of that sort of combined to get borrowers filing claims, such that by November 2017, there were 118,000 borrower defense claims that had been filed, representing around $2.4 billion in potential loan discharges. So suddenly the department has a big problem, right? Because they've got virtually no process or procedure in place. They've got a standard that's based on state laws that's hard to enforce and administer, and now they've got 118,000 borrower defense claims to deal with. So the prior administration said, well, we're gonna create a framework, right? And in 15-16, they carried out a negotiated rulemaking, which many of you know is how the department makes rules. They sort of go through this process and they get negotiators together and they try to hammer out a rule, and then the department will propose something, folks will comment, and then they issue a final rule, right? So in 15-16, they got all those folks together and they talked about it, but no consensus was achieved. So the people around the table did not come to agreement on what the rule should look like, which means the department had the authority to sort of propose its version of the rule based on the feedback and whatnot that it had received to date. That new BDR2 rule, so I'm calling it BDR2, BDR1 being what the department created back in 1994. BDR2 was published November 1st, 2016 and was scheduled to become effective July 1, 2017. And then, and this is important, in January 19th, 2017, right before the change in the administration, the department issued supplementary procedures governing those recovery actions. Remember, we talked about the fact that there's a distinction between the process used to determine whether or not to discharge the borrower's loan and then a recovery action against a school to recover on any amounts discharged. So what's interesting is what was published November 1st, 16 and set to become effective July 1, 17 was a massive rule, but from the bar defense perspective, it largely dealt with that discharge determination, right? And it wasn't until January 2017 that the department published revisions to what would essentially be the recovery process. What's interesting is those regulations became effective immediately because they weren't subject to negotiated rulemaking and they were considered sort of technical and outside the scope of the negotiated rulemaking process. And they are on the books now. They became effective immediately and they continue to be effective. Nonetheless, in 17-18, the new administration delayed almost all elements of BDR2 and virtually everything that was set to go effective July 1, 2017. They said we're going to delay all of that stuff that the prior administration put together until July 1, 2019, and in the interim, we're going to carry out another negotiated rulemaking over this same rule, and we're going to create what we call BDR3, and it's starting to look like a Star Wars episode. Once again, consensus was not achieved. Okay, so the folks came around the table in late 17, early 18, and they tried to hammer out a rule. They didn't get the consensus. Many of you know I was actually one of the primary negotiators and participated in that process. So I went to D.C. and sat around the table with other folks. It's one reason I'm so invested in this rule. So the department, consensus wasn't achieved, proposed its new version of borrower defense on July 31st, 2018. And that's what we're talking about today, is the proposed rule that this administration has come up with to replace BDR2 and, for that matter, BDR1, right? The comment period ends at the end of this month, August 30th, 2018. The final rule will likely be published by November 1st this year so that it can become effective under the department's laws by July 1st, 2019. So that would be by July 1 of next year. Okay, here's a comprehensive BDR timeline. I'm not going to go through it, but it's in the slides if you want to look through all the machinations in more detail. So let's talk about what this administration is proposing and what you might want to comment on. First of all, I put this slide up because it's really important when you're talking about this borrower defense framework to think of it as a framework. It's a lot of different pieces, but they all hang together, and it's really a balancing act. And it's hard. It was hard to negotiate, and I think it can be hard to really understand the import of any particular one of these pieces if you're not always sort of thinking of it in relationship to the other. So I'm going to go through these in subsequent slides in a little more detail. I'm going to give you some recommendations on what you might want to comment on. But I want to make sure that you have the big picture here and you're sort of seeing this as it relates. Okay, so the first thing is this administration is sort of struggling with this idea, and they've actually solicited comment on whether or not borrowers should only be able to bring defensive claims or whether they should be able to assert affirmative claims as well. What's the difference? A defensive claim is the claim that a borrower actually asserts in the context of a collection proceeding. The department says, you owe us money, you've defaulted, you're not repaying on your loans, and the department says, here's my defense. I'm sorry, the borrower says, here's my defense. An affirmative action would essentially mean that a borrower outside of the context of a collection proceeding, so without having gone into the default or anything like that, just says, you know what, I think my school did something wrong, I should have my loans discharged, I should be able to discharge my loans, and they can essentially file an application. So there's this question of, given the way the statute reads, should we be limiting this regulation to defensive claims only, or should we also be making affirmative claims available to borrowers? Now, whether it's an affirmative claim or a defensive claim, doesn't matter, the department has proposed a new federal standard. And the idea here is, remember I mentioned earlier, the department has said, look, it's really problematic for us to try to figure out whether or not something a school did gives rise to a cause of action under state law. Again, you're talking about bureaucrats at the U.S. Department of Ed. If you got an online program, sometimes it can be hard to even know which state law applies. Is it where the student's resident? Is it where the faculty member is living? Is it where the school's physical location is located? So it's sort of a mess for the feds, and they said we need a federal standard, something in federal law that we can use to make the determination. The other thing that they've done, and this is really important and very different from what the prior administration suggested, is they've limited it here to essentially a misrepresentation standard. In the 2016 version of the rule, some of you will recall, there was this idea that a borrower could show a breach of contract, or maybe a borrower could show a judgment in state court and bring that as the basis for a borrower defense claim. And what they've said here is, look, it's just a misrepresentation. That's the standard. Now, if you can show that you have a judgment in state court and the judgment is that the school misrepresented, well, that would still be sufficient potentially to satisfy the misrepresentation standard. And that's what this department has said. But they said, look, we're not going to break it out into lots of different pieces. We've got one new federal standard, and it's really based on misrepresentation. I'm also going to talk a little bit about the evidentiary standard, but that's kind of up in the air right now too, and the department is fluctuating and asking for comment on whether they should go with the idea that a borrower has to show by a preponderance of the evidence that a misrepresentation occurred, or whether they should show by some higher standard like clear and convincing evidence that a violation occurred. And I'll talk to you a little bit more about what those standards mean, because they are very important in my view. We talked about misrepresentation. It is not a mistake standard. That's a big piece of all of this. Prior versions of this rule or suggestions would have permitted potentially an unintentional act on the part of an institution to be characterized as a misrepresentation. The department has said no, it doesn't have to be intentional, but it at least has to have been done with reckless disregard, right? So there has to, either school has to be acting intentionally or it has to have its head in the sand, right? And you can look up the definition of reckless disregard later, but the idea is it's sort of like negligence, right? You should have known better. Financial harm. There's also this idea here, the department's proposing that not only does a school have to have misrepresented, but, you know, there has to be some damage. There has to be some financial harm that the borrower shows, and that helps the department in determining what kind of loan discharge might be appropriate. So if a student, you know, has suffered hundreds of thousands of dollars in financial harm, that's one thing. If they've suffered $5,000 or $10,000 in financial harm, that's another. Borrower defense exclusions. One of the really important concepts here is that the department is drawing a little more of a defined box around what can constitute a borrower defense claim, and they've offered some additional examples of what would not constitute a borrower defense claim, which I think is good for everybody, students, taxpayers. It's good for us to know what is really in play here and what's not. Time limits for claims. So some of you, the lawyer types, will think of this as statute of limitations. But the idea is, you know, how long does a student or borrower rather have to bring a claim to assert that defense? And the department's come up with some new ideas there, which are really important. Time limits for recovery actions. So, you know, how long can a borrower go before, how long does a borrower have to bring a claim? But then after there's an adjudication and a discharge, how long does the department have to turn around and initiate a recovery action against the school? So another really important concept. And then finally, they've proposed, as you would expect, a claim process. So all of these other things I'm talking about really go to, largely go to sort of the standard. What is it we're adjudicating? What has to be established and with how much evidence? But then there's sort of what's the procedurally, what's the process, right? How do you bring the claim forward? Who gets to respond and when? Is there an appeal right, et cetera? All of this hangs together to form this framework. And I will say as a blanket statement, from a school perspective, so when I was negotiating, my responsibility was to represent, negotiate on behalf of general counsels and attorneys at institutions of higher education, and I viewed myself sort of representing the risk managers. And one of our real objectives was to come up with a rule that, looking at all these different elements, balanced the risk, right? I mean, institutions are going to have to take on some risk, right? We want students to be able to bring claims and be successful if they have claims of merit, and sometimes that process may still result in a frivolous claim getting through, and there's just some risk that's associated with that. On the other hand, we also want institutions to have an opportunity to defend themselves, and students should have to, or borrowers should have to bring a certain amount of evidence to the table, and occasionally there are going to be borrowers who have good claims and they just don't have the evidence available, and so that places some risk on them, right? And the idea is to come up with a framework that sort of allocates that risk in a fair way. It is certainly my opinion as a defense attorney and someone who represents schools that this rule that has been proposed represents a far fairer allocation of risk among borrowers and schools than the prior version of the rule that was put out in 2016. And that is my way of saying to you that if you are a school on the line, this is probably a rule that you would want in many respects to support, right? Certainly as opposed to the prior version. And it does create it gives a way, a mechanism for borrowers to bring claims, and it gives protections and abilities for schools to defend themselves against frivolous claims, and it gives the taxpayer and the Department of Ed a way to work it all out and potentially see that justice is done. You want to pay attention to this, and again, if you like what you hear over the next few slides, I encourage you to comment, because it's important, once again, to support the department when it proposes a rule that works for you. Okay, so let's talk about some of these things in a little more detail. One thing I did not mention that I do want to hit off the top is the revised claim form. So there was an application over the last 3 or 4 years that the department started to make available for borrowers who wanted to assert affirmative claims, because the department over the last 3 or 4 years, though nothing was really in the law, just started allowing affirmative claims, meaning students did not have to be in default or anything like that. They could just file a claim seeking loan discharge based on a barred offense or on the idea that their school had done something, right? So the department here proposes in the regulation to articulate certain things that have to be in that claim form. This, in my view, is a win for institutions. Among other things, it would require a borrower to make the claim under penalty of perjury, provide evidence in support of the claim, state an amount of alleged financial harm, sign a waiver permitting the school to use the student's education records in its defense, because otherwise you have a FERPA problem potentially, and to acknowledge that if the borrower in filling out the application would have to acknowledge that if they get 100% loan discharge, the school can refuse to verify or provide an official transcript associated with the discharged loan. And that's that was sort of a hard conversation we had during negotiations, but the schools pointed out, they said, look, if someone's going to discharge all their loans and I'm going to have to pay back the U.S. Department of Ed, the student doesn't still get the transcript. It's also really important that students understand that, right? I mean, if they've graduated and they are using that degree, they need to understand that if they seek a loan discharge so that the school has no longer been paid, there may be disagreement between the school and the student as to whether or not that discharge was valid, as you would expect. And if they get that discharge, that the school is no longer going to be obligated to verify their transcript to provide them with the transcript. This is good for students and borrowers to know as well, but it's an important protection, I think, to some extent for institutions. My recommendation is I would support this. I did not see anything in the proposed claim form that would really present a downside for institutions. The question of affirmative claims. So this is the question the department has put on the table, and they are very actively soliciting comments whether or not affirmative claims should be permitted, recognizing that if they allow affirmative claims, quote, we would need to develop appropriate deterrents to frivolous claims, right? Because an affirmative claim essentially, again, means that someone could just fill out an application, right? Having to go into default is, in and of itself, somewhat of a deterrent, right? If someone can just fill out the application, it makes it a lot easier for a frivolous claim to simply be lodged. What's interesting is this administration has actually proposed 2 different federal claim standards depending on where they come out on this. So in this proposed rule, and I'm going to talk about it, they said, well, this is what we would suggest as a claim standard for defensive claims. And if we allow affirmative claims, this is what we would propose as a potential standard for affirmative claims. And the latter is a little more stringent, reflecting the department's concern that affirmative claims, because there is less of a deterrent, like default, for example, having to go into default, there needs to be a slightly higher level of process protection for schools. So, schools may come out in different places on this. I mean, the affirmative claim idea certainly creates risk for institutions. A student having to go into default is a deterrent against frivolous claims, and I could understand some schools saying, well, if the department's interested in entertaining this idea of defensive claims only, that's the thing we want to support. I will also say, if you read the statutory language, you know, it is a, quote, borrower defense. So there is some suggestion here that really the idea was defensive claims, although I won't suggest that Congress gets into that in that much detail. I will also tell you, I know a lot of schools, some trade associations representing schools have taken the position that really affirmative claims should be permitted because many people from a public policy standpoint don't feel it's appropriate to require a student who has been wronged to go into default to be able to assert that claim. And I will tell you personally that makes sense to me, and I articulated as much on record at the negotiated rulemaking. But, big caveat here, supporting affirmative claims provided that the procedural protections remain in place and the evidentiary standard is strengthened, right? And the department has opened the door for this. In soliciting comments, they said, we recognize if we allow affirmative claims, it's important to have procedural protections. So my suggestion would be, if you are going to support the affirmative claim option, that you also caveat that and note that you agree with the department that it's extremely important to keep the procedural protections in place. And I personally am recommending and suggesting to folks that the evidentiary standard strengthened. And again, typically when I do these webinars, I don't take personal opinions on things, but I've already recommended all this on record as part of negotiated rulemaking because it was my role to express my opinion. So I'm basically telling you what I already have gone on record as believing. The defensive claim standard. So remember, the department has proposed one sort of standard for defensive claims and a slightly different one for affirmative claims. For defensive claims, so these are claims that would be asserted in the context of a collection proceeding, the department would approve the borrower's claim if the borrower established by a preponderance of the evidence, there's your evidentiary standard, that the institution made a misrepresentation upon which the borrower reasonably relied under the circumstances. What's that mean, under the circumstances? It means if you've got a borrower that was in a state of duress or a borrower who is not as sophisticated, you take that into account because those are the circumstances. So all borrowers aren't treated as the same type of borrower, right? More sophisticated, educated borrowers might not be deemed to have reasonably relied in the same situation where a less sophisticated borrower might be deemed to have reasonably relied. That's why that under the circumstances is important. When deciding to take a loan to enroll or continue enrollment at the institution and the borrower suffered financial harm as a result of the misrepresentation. So again, a borrower would have to establish that a misrepresentation occurred, and we'll talk about that definition in a minute, that they reasonably relied upon it under the circumstances when they were deciding to take out a loan or enroll or continue enrollment, and that they suffered financial harm as a result of the misrepresentation. So a borrower, by the way, and I'll talk about this a little bit more later too, but a borrower could suffer financial harm, and that does not exactly mean it's a basis for a borrower defense claim. They have to suffer financial harm as a result of a misrepresentation that the school made, and there has to be a direct causal connection there. That's a basis for a borrower defense claim, right? I would support this proposed rule based on what we negotiated, based on past versions of the rule. I think this is a very fair standard for schools. But again, I would support replacing that evidentiary standard at the very top, preponderance of the evidence, with clear and convincing, and I'll talk about that more in a minute. So the affirmative claim standard is very similar, but it's a little stronger. So the department, if you had a borrower assert an affirmative claim, no collection proceeding, filling out an application, right, then the borrower would have to establish by, again, preponderance of the evidence that the school did what? With an intent to deceive, knowledge of the falsity of a misrepresentation, or a reckless disregard for the truth, made a misrepresentation of material fact, opinion, intention, or law upon which the borrower reasonably relied when deciding to take a loan to enroll or continue enrollment at the school, and that they suffered financial harm as a result of the misrepresentation. Now, what's different here, and what do we want to really focus on? First of all, you'll see that first bullet, with an intent to deceive, knowledge of the falsity of a misrepresentation, or a reckless disregard for the truth. Now, your initial reaction might be, well, that's a much higher standard than the prior claim, because it didn't have anything about intent or reckless disregard or falsity of misrepresentation. I'm really going to get into the weeds here, but this is a lawyerly kind of point. It's an important point. The definition of misrepresentation requires that the act or omission in the least was made with a reckless disregard for the truth. So that first bullet doesn't really get you anything. Even for defensive claims, Remember, and I'm going to go back to the prior slide, remember, the first thing a borrower has to establish is that the school made a misrepresentation. And a misrepresentation incorporates, that concept on its own incorporates the notion of reckless disregard. So the truth is, and this is a little confusing, I don't know why the department did this, but the truth is this added requirement under the Affirmative Claims Standard isn't really an added requirement. Does that make sense? Because under the definition of to be a misrepresentation, there has to be a showing of at least reckless disregard. And here, that's the lowest of these three options. This is disjunctive. So a borrower would have to show not intent or knowledge of falsity, but at least reckless disregard. Okay. Made a misrepresentation of material, fact, opinion, intention, or law. So this is different because it adds the notion that the misrepresentation has to be of something material. Material, fact, opinion, intention, or law. So that ups the standard a little bit for the Affirmative Claims Standard, upon which the borrower reasonably relied. Now here, remember that under the circumstances, it's been removed. So this becomes an objective standard, right? Any borrower would have to have acted reasonably without regard to their particular level of sophistication when deciding to take a loan and then financial harm. So there's a little bit of an elevation here in terms of the standard, maybe not as much as you would think upon first blush. Again, it's still a very fair standard for schools. I would suggest supporting the proposed rule once more with a higher evidentiary standard. The other thing that I just real quickly want to point out is with regard to, well, you know what, I'll just talk about it in a minute when I get to the evidentiary standard. Okay, so here it is. The department proposes preponderance of the evidence. They have very expressly labeled this a preliminary decision. So they've inserted preponderance of the evidence as the evidentiary standard, but they said this is preliminary. And they on multiple occasions have solicited, quote, comment on whether claims should have to be supported by clear and convincing evidence rather than a preponderance of the evidence. Okay. So why does Erin advocate for clear and convincing? Because this creates a higher standard for borrowers, right? And it's going to make it a little more difficult for them. And particularly say, Erin, you've got intent, you know, or not intent, but you got reckless disregard, you got, you know, financial harm, all these other components. Why would you also advocate for a higher evidentiary standard? Here is the concern. And this is going to be important if you want to comment on this as well. And we talked about this extensively during the negotiated rulemaking. The point was made repeatedly by folks who wanted to advocate for a lower evidentiary standard, preponderance of the evidence, that it is often used in litigation and not uncommonly, not in fraud necessarily in sort of those higher end types of misrepresentation, but in your standard Consumer Protection Act claims in a lot of jurisdictions, for example, preponderance of the evidence would be used. And by the way, I'll take another step back and say, for those who aren't familiar, preponderance of the evidence means, the way I've heard it often characterized, it differs a little from jurisdiction to jurisdiction, but basically it means more likely than not, 51%. So, you know, if you're weighing the scales, you've got what's in front of you, the person making the decision thinks that the scale tips, you know, 1 iota in the other direction, and that makes it more likely than not, right? It's what I would call sort of a lower level standard, right? The highest level standard being beyond a reasonable doubt. And then there's what I'll call sort of a medium standard or mid-level standard, which is clear and convincing, and that sometimes is characterized as substantially more likely than not. And you might think of that as requiring, you know, sort of 75%, 70 or 75%, right? So why is it that we think that mid-level standard would be appropriate, particularly when, like you say, in a lot of jurisdictions right now, if you bring Consumer Protection Act claim or something like that, preponderance of the evidence might be used. Here's why. Because for a borrower or litigant to bring a claim in court or even arbitration takes a concerted amount of effort and on its own requires a fair amount of cost. Financial cost, personal cost, you've got to pay to bring the action in court. You may have to retain a lawyer. Most folks probably will. You're going to have to be willing to go through discovery, potentially make yourself available for depositions. You know, there's a lot that you're going to have to commit to, financially and otherwise, if you're going to go to court or even go to arbitration, right? That's all cost, and those are all deterrents to frivolous claims. It's the barrier of entry. The thing about this context is to make an affirmative claim, to be very clear, all someone has to do, a borrower would have to do, is to download an application off the internet and fill it out and send it in. There is no cost. No attorney is required. You just have to make the allegation, and the borrower defense claim has been made. So the idea here is, remember that first at the opening I was talking about how this is all sort of a balance, right? You're talking about balancing all these different concepts to achieve a fair risk allocation, okay? My argument would be, and was during negotiated rulemaking, and this is my view as a defense attorney who works for schools all the time, is that, you know, my concern is it throws the balance off. If there's no barrier to entry and all someone has to do is lodge an application and you need no additional or corroborating evidence necessarily to support that claim, and the standard is just more likely than not, then what happens when someone fills out a claim and adequately and accurately alleges that the student with that the school with reckless disregard made a misrepresentation? So all those elements are there, and they fill that out, they tell their story and put in the claim, right? And let's say this is several years after the borrower has graduated and the persons involved at the school aren't there anymore, or the school doesn't have records anymore, you know, so the school has nothing to provide, or at best can just provide a counter statement, say, well, we don't think that's true, right? It doesn't matter that you've got all these requirements relating to reckless disregard, et cetera, because, you know, now, well, the person stated a claim and there's no additional evidence, it's just more likely than not. So you see why the evidentiary standard is important. It's because there's such a low barrier of entry to affirmative claims. If we're going to support affirmative claims, I think it's very important that when a borrower files an affirmative claim and fills that application, unlike with litigation or arbitration where there's going to be all this cost and all this additional commitment, here there needs to be at least some requirement that they bring some additional evidence to the table, right? That's the idea anyway. So I would say if you're going to support affirmative claims for an evidentiary standard, support clear and convincing, right? And I would also actually suggest that even for defensive claims, clear and convincing is an appropriate standard. And I'll explain a little more as to why in a minute when I come back to the time limitations. Okay, let's talk about the definition of misrepresentation. A statement, act, or omission by an eligible school to a borrower that is false, misleading, or deceptive, that was made with knowledge of its false, misleading, or deceptive nature, or with a reckless disregard for the truth. So remember, that's why I said that in the affirmative claim standard, including that language about reckless disregard really didn't get you a whole lot because it's built into this definition of misrepresentation. And that directly and clearly relates to the making of a loan for enrollment at the school or to the provision of educational services for which the loan was made. I would support this standard. If you were paying attention to the 2016 version of the rule, the department was using a definition of misrepresentation that already exists in a different part of the regulations. And the way that definition reads, I would characterize it as a much lower standard, meaning that an inadvertent mistake on the part of an institution could be characterized as a misrepresentation. Here, the department has said, look, if someone's looking to discharge all their loans, we don't think that's an appropriate definition of misrepresentation to use. We think this is an appropriate definition, and in the least, there needs to be this element of reckless disregard, and it needs to be false, misleading, or deceptive, et cetera. This is a pretty good misrepresentation standard. It's pretty fair for institutions, so I would certainly suggest supporting it. Okay, the department also gives what do we have, 8, 9, 10, 11 different examples of what might constitute misrepresentation. Now, I have not written them all out here, but what all of them essentially involve is the department saying, if you told a student this was true about, and I'll use the very first box, licensure passage rates. If you said our licensure passage rates for our program X, our nursing program, 100%, and actual circumstance is that they're 50%, and that's a material difference, which I would suggest in that case it is a material difference. But the department's saying if you got a material difference between a representation relating to one of these topics and the actual circumstance, that could be evidence of misrepresentation. Now, why? I've got some boxes here that have coloring around them. The yellow boxes, and the red box for that matter, do not include a materiality standard. Part of that is because of the way they're written. But I just wanted to highlight for those particular topics, the department does not reference or require necessarily a material difference. So for example, with endorsements or testimonials, they just say, look, if you're using an endorsement or a testimonial and you don't actually have it, in other words, it's a fake endorsement or testimonial, no one has authorized you to give it, that's a misrepresentation. It's not about whether it's material. I mean, you didn't have authority to use the endorsement or testimonial. I do, though, want to focus on the red box, availability of nature or financial assistance. So, and I noticed we had a couple of folks signed up for this webinar today who were fellow negotiators of mine, so a shout out to you guys. And it was actually several of the financial aid, the folks representing the financial aid community at the negotiated rulemaking that pointed this out to me. I had not considered it, but one of the things the department is suggesting as evidence of misrepresentation would be a difference, not material, a difference between what you told a student was the availability or nature of financial assistance at the time of enrollment and what it turned out to be after the fact, after they enrolled. And several of our financial aid negotiators raised their hand and said, well, wait a minute. You know, we do a proposal, you know, tuition projection for students all the time at the time of enrollment. And it will say, this is how much Pell we think you'll get, this is how many loans you'll think you'll get, et cetera, et cetera. And then their circumstances could change, right? I mean, halfway through their 4-year program, Uncle Jimmy could give them $20,000 for their education. They could get a Coca-Cola scholarship. You know, all different kinds of things could happen that would alter the nature or availability of their financial assistance. And so folks said, rightly, you know, there should be some sort of allowance for that. I mean, if we have a disclaimer or, you know, if the events that occurred were outside our control, here's the thing I want to point out to the folks on the line. The department did not build in any kind of allowance of that nature. And they address this in the commentary very briefly, and they said, you know, some people raised issues, but then they kind of blew it off. And that's not me pointing the finger at the department, but it's just making the point that they really did not give an explanation as to why this concern that was raised isn't a legitimate concern or shouldn't somehow be managed in the language. What I would suggest is that you look at that particular example, and particularly if you're one of the financial aid folks on the line, maybe think about it, and maybe this is one of the areas where you want to comment. And you want to say, look, we generally support the definition of misrepresentation and the examples of misrepresentation, but here you are creating an idea, this notion that something could represent misrepresentation when there is a very good likelihood that this, you know, circumstance could occur, and for reasons that are completely outside the control of the institution. So that's a great opportunity potentially for comment. Financial harm. This is another place in the 2016 version of the reg, and for that matter in BDR 1, there was really no concept or allowance for or connection to the financial harm, and there's no requirement that a student necessarily demonstrate financial harm, or borrower, I should say. Here, the department is saying, I mentioned earlier, the misrepresentation has to lead to financial harm, and the borrower has to demonstrate that financial harm. So then the department says, well, what does that mean, right? They indicate it should be monetary loss, and they set forth a number of exclusions from this idea, and these are really important. So damages for non-monetary loss, such as personal injury, inconvenience, aggravation, emotional distress, pain and suffering, punitive damages, or opportunity costs. None of that is on the table. These are really important exclusions for institutions, right? So what that means is a borrower can't claim my school did something and should be penalized for it, or my school did something and it caused me great emotional distress and aggravation, right? Nor can they say my school did something and if I had never gone to this, I wouldn't have gone to this school but for that misrepresentation, and if I hadn't gone to the school, I could have been a gazillionaire, and so that's my opportunity cost. All of that is being taken off the table. What the department is saying is, look, it's got to be monetary loss. Okay, and it's got to be predominantly due, it cannot be predominantly due to intervening market conditions. Actually, I think I wrote that bullet correctly. So, oh no, it's excluded. I'm sorry, I did write it. So one of the exclusions is monetary loss that is predominantly due to intervening market conditions, which is another really important point, right? So if the economy tanks and nobody made money and everybody, you know, suffered financial harm, then that wouldn't constitute financial harm that could be a basis for a borrower defense claim. Financial harm arising from the borrower's voluntary decision to pursue less than full-time work or not to work, or resulting from a voluntary change in occupation. So these are all really important exclusions. And again, you know, I just want to highlight for folks I had some concern originally when the financial harm concept was first floated by the department during negotiations and elsewhere. I was talking with folks, and they said, well, wait a minute. Someone could graduate, and then they could pursue less than full-time work, or they could simply take a job that doesn't pay as much, whatever, and then they would be able to show financial harm. And I just want to, again, note, it's not only that they have to show financial harm, they have to show that the school, there was some act or omission on the part of the school that caused that financial harm. So do keep that in mind. I would suggest supporting this rule. I think it's very fair to institutions. Examples of financial harm. So in addition to that definition, the department actually gave 4 examples of things that would constitute potentially financial harm if demonstrated by a student. An inability to complete the program because the school ceased offering the required component. Extended periods of involuntary employment unrelated to market forces. Significant difference between tuition and fees represented and those charged. Inability to obtain employment when it was expressly guaranteed. Now, I don't know many schools that are expressly guaranteeing employment, and if you are, you should give me a call. But the other 4 of these you might want to look at and think about, and if any of them make you uncomfortable, you might want to comment on them. But again, I know I sound like I'm beating the dead horse here, but again, if this happens, it's not a basis for a bar defense claim. What a borrower would have to show is that a school did something that caused one of these things to happen. That would be a bar defense claim. Okay, BDR claim exclusions. I mentioned earlier the department has drawn a slightly tighter box around what can actually be a bar defense claim and things that they are putting outside of that box. The general quality of the student's education or reasonableness of an educator's conduct, that's a really important exclusion. That is essentially would be the kind of claim someone would make in an education malpractice claim. This is basically saying you just don't do a good job. You're just not a very good educator. You didn't teach me well. Academic disputes and disciplinary matters, breaches of contract, and let's say otherwise constitute a misrepresentation. Any claim that is not directly and clearly related to the making of the loan or the provision of educational services. This is all good. This is all good. Again, I think for students and borrowers alike, or borrowers and schools alike, it's important to have a really clear understanding of what goes inside the box and what goes outside the box, and I would support this. So the claim process. There were a couple, 3 surprises in this proposed rule, and I think this was one of them. We had just a lengthy conversation about what this process should look like, and interestingly enough, and as you would expect when you put 17 people around a table, it sort of got increasingly complicated as everybody tried to add their thing. Perhaps reacting to that, the department came up with a very simple idea here, and I think it works for the most part, but have a couple of suggestions for you. So the borrower would submit a claim application and their evidence. And then the department would notify the school. That's important. The 2016 version did not guarantee even that schools would get notice, which was sort of an incredible omission. The department would notify the school and provide the school a copy of what the student submitted, so the claim application and any evidence. They would also give them the waiver that the student signed when they filled out the application permitting the use of the student's records in their defense. Then the school would respond within whatever the specified time frame might be. The department would send the school's response and any related evidence to the student, and the department suggests that it's sort of going to be the go-between here. There is an implication in the regulation, though it's not as express as I would like, that they're going to make sure that the student has all the stuff that the school provides and that the school has everything that the student provides or that the department is otherwise relying on. What do I mean by that? So let's say there's an attorney general's investigation into a school or a related school or whatever. And the attorney general has all of this information and the department has it in its possession relating to the school. The department can use that information, right, and rely on it and evaluate it as potential corroborating evidence to the student's claim. So the student doesn't have to get a hold of it and supply it. If the department's already got it, they can look at it. But, and here's the important thing, but the school is guaranteed a copy. So if the department has some evidence beyond what the school or the student provided, the borrower provided, what the department is saying is we're going to make sure the school gets a copy. If we're relying on it and we're evaluating it and coming to our decision, the school's going to get a copy of it and ostensibly get the opportunity to comment on it as well, right? And that's an important, very important procedural protection for schools. So after this document exchange occurs and everybody's evaluated everything and had a chance to comment on it, Staff reviews all the documentation received and issues or on hand and issues a written decision notifying both parties of the outcome and outlining the reasons, et cetera, and any discharge or relief. Then, finally, in accordance with time limitations, if the department so chooses, and they have made very clear that they intend to pursue all these funds, they would initiate a separate action against the school, a recovery action, to establish the liability and recover amounts owed under, and this is subpart G, 34 CFR 668.87, right? So this doesn't look too bad, but let's talk about the problems. It's really a mixed bag. So on the good side for schools, there's no group claim process. If you paid attention to the 2016 version of this rule, there was sort of a class action concept where the department could just initiate a class, and that was a very frightening proposition for defense attorneys in schools, right? So there's no group claim process, and part of that idea there, and the department said this and we talked about it in NEGREG, is, look, Congress established a process by which individual borrowers can assert a defense to a collection action. There has to, the mechanism then that flows from that has to be individualized. Now, that doesn't mean that the department gets 50 individual claims. It can't look at the evidence across all those claims, but it's still got to consider each one individually and decide on each one individually, even though it may be aggregating evidence and looking at things for the whole group. Okay? There's no distinction between open and closed schools. You may remember in 2016, the department proposed a different process for closed schools, essentially affording them less due process and protection. Here, it's just one individual claim process that's been proposed. And there's a guarantee for schools of the right to review and submit documentation, which is really important. Okay, what's not great about this? First of all, it's still staff that's reviewing this, right? It's still staff. It's not an administrative law judge. It's no special component. It's just a staffer at the department. And the danger there is, staffers they're sitting in offices down the hall. They can be, and this is no disrespect intended to the U.S. Department of Ed, but this is just the case with all of us. They can be subject to political pressures, right? And they are less insulated than some other elements of the department, like I would suggest the administrative law judges, right? So it's just a staffer doing this review. There are no specific timeframes in the adjudication process, so the department guarantees schools the right to respond, but it doesn't guarantee them in a particular amount of time in which to do so. And the problem there is, what that means is if you get an administration or a staffer that is hostile to schools down the road, they could say, you're guaranteed a right to respond, and it is 4 days from now, and here's all the evidence. Good luck. So you want guaranteed timeframes, I think. And the last thing that I thought was very disappointing was there's no voluntary resolution process on the front end, and there's no appeal. What do I mean by that? So one of the folks, Chris DeLuca, a fellow negotiator, great guy, fellow attorney, had proposed, and it was generally by all parties at the reg table. We had slightly different variations, but everybody sort of embraced this idea, if it was done a certain way, of there being a voluntary resolution process before a claim was filed. Or at least if a claim was filed, that there would be an opportunity, voluntary, for the borrower and the school to resolve things informally prior to an official adjudication. And Chris DeLuca, again, noted rightly that the Office of Civil Rights of the U.S. Department of Education does this. So it's not like we're inventing something new, right? And even during NEGREG, the department said, well, it's not really what we're conceiving of, and we think it would cost too much, et cetera. I personally disagree with that. It is very hard for me to imagine that it would cost more for the department to appoint a mediator of some sort on the front end. They're not really mediating, but sort of a go-between just to facilitate this process, than it would be to allocate an adjudicator plus the administrative law judge and the attorney that are going to have to take part in the subpart G proceeding on the back end, right? If they want to recover on any amounts that are discharged. I cannot imagine that it is more expensive to provide a staffer on the front end to help the parties connect and trade documents. But, it's for the department to decide. The other thing that was surprising, the department during NEGREG suggested or seemed to suggest that, they would either go with one or the other. You either can have a voluntary resolution process or you can have an appeal. You will note there is no appeal. There is no appeal. So once this, let me just go back to the slide. Once you get, I'm on the 1, 2, 3, 4, the fifth box, right, the bottom on the left. Once staff reviews and makes a decision and says, this is my decision and I'm not granting relief or I am granting relief, it's done. It's over. There's no appeal. Now, wait a minute, the schools are saying. What about this last box? I thought you said there's a subpart G proceeding. That's true, and it was often the case that some of the consumer advocates and others said, well, schools do get an appeal. They get a second bite at the apple. I want to be very, clear to schools that a Subpart G recovery proceeding is not a second bite at the apple. It is not what we in the law profession would call a de novo review. In other words, the ALJ isn't going to just re-adjudicate everything from scratch. What happens is the ALJ essentially, you come in and the decision has already been made, and then the standard, it's a review standard. You're going to have to demonstrate that the decision made by the staffer was clearly erroneous, right, which is a pretty high standard. So it's not like it's a fresh preponderance of the evidence or even clear and convincing, whatever that standard might be and whatever all the, the process around the adjudication process might be. If you end up in Subpart G, the decision's already been made, and it's already been decided by the department that you owe this amount, and the only way that you're going to overcome that is in front of the ALJ to demonstrate that the staffer's decision was clearly erroneous. So it's not a second bite at the apple, and it's not an appeal, whereas an appeal would have been sort of a second look, right, at the adjudication decision itself. Okay, so my recommendation is I would generally support the rule. You could throw in an appeal concept if you want to, but in my mind, the most important thing to advocate for here is guaranteed minimum time frames in which to provide responses. And what we've always suggested is, and you see this in other administrative proceedings, once a claim is filed by the borrower, a school would get 45 days to respond, then the borrower would get 30 days to reply, and then the school would have a final 15 days for a rebuttal, and then that would be it, right? And that's pretty common. Time limits on asserting a claim. So now I'm talking about, how long can it go before the claim gets stale, right, and they can no longer make the claim. Really important, the department has suggested, again, two approaches, one for defensive claims and one for affirmative claims. So for defensive claims, a borrower would have to assert the claim during the proceeding in compliance with applicable deadlines. So what the department is saying is, and I think this makes sense, it's a defensive claim, right? So there's some sort of collection proceeding, and the department's going to say you've got 45 days to assert any defenses you've got, and that's when the borrower would have to do it. But keep in mind, if the borrower has a 20-year loan repayment schedule and they default in year 18, that could mean that the department initiates the collection proceeding 18 years after the borrower has graduated from your institution or left your institution, and that's the point at which the borrower is asserting the defense, 18 years later, right? So on the one hand, I think when people may have seen this in the proposed rule, they say, oh, 60 days. But that doesn't mean 60 days from when the borrower graduated from your school. It means 60 days, or 45 days, whatever the required time frame is within that collection proceeding. But at any point at which a borrower defaults, which could be any time over the life of the repayment term, they could assert that defense, okay? And I'm going to talk about this in a minute with regard to recovery actions. For affirmative claims, the department would simply say, so this is not in the context of a collection proceeding. Borrower just has to fill out or wants to fill out an application. The borrower would have to assert the claim within 3 years from the date they are no longer enrolled at the institution. So I'm going to suggest that you support this. First of all, the affirmative claim standard is what we advocated for during negotiated rulemaking. It was very unclear where the department was on this. I think this is a very fair standard for schools. Part of the reason I think it's a fair standard, and I know the consumer advocates and others don't like it at all because they feel like, borrowers should have more time to bring a claim. But the challenge is, and that we kept pointing out, and I think this is a very reasonable position for schools, is that the federal government, including the U.S. Department of Ed, is telling organizations, businesses, schools, not to keep records beyond a certain point for all the privacy and data breach concerns, among others. So under current federal law, you're only required to keep certain records relating to federal financial aid, all those eligibility records, et cetera, typically for a period of about 3 to 4 years, depending on the particular circumstances. And then after that, the feds, again, and states and a lot of others are saying you should get rid of those records, including some consumer advocates, right, because they don't want their consumers' records to be out there. And every day you keep those records, it increases the likelihood that they will be breached, right, or hacked. And we said, well, wait a minute. It's not fair that we're being told to get rid of all these records, and then someone could bring a claim and we would no longer have the records we needed to defend ourselves, right? So that's really, I think, the basis why the department landed here after all. But I also think it makes sense to support this approach to defensive claims, right? Because it is hard. I mean, Congress directed the department. They said, your job is to say what a borrower can assert as a defense in a collection proceeding. How could you then say that if the collection proceeding is initiated 5 or 10 or 15 years later, they no longer can assert that defense. I mean, that's the whole idea, is that that's the moment in time in which they get to assert the defense, right? But I understand it still creates a problem for schools, because now I potentially have some sort of collection proceeding that's occurring 18 years, like I said, afterward, and there's no bar on that. The collection proceeding can go forward, and the borrower can assert the defense. So where does that leave schools? Ha-ha. Time limits on recovery actions. So this is how I would propose to solve this problem, and I will just suggest that there was some support for this even within the department, although I don't want to overstate that, but I had a couple of conversations during NEGREG, and I think that they were thinking about this kind of thing too. So the idea would be, right now under the proposal, the department has 5 years from the discharge to pursue recovery against the school, period. Anytime they discharge, affirmative claim, defense claim, doesn't matter, they got 5 years. And this was actually an improvement. Originally, when the department drafted the reg that we looked over in negotiated rulemaking, there was no limitation. Here is what I recommend, and it's really as a solution to the problem I was talking about a minute ago. So support the proposed rule, but in cases of discharges stemming from defensive claims, that the department would cap the recovery at the amount the borrower paid on the loan during the first 5 years following their last day of enrollment. So let me sort of give you an example to explain. So let's say we've got that situation where a borrower's got a 20-year loan that they're paying back, and they're, 18 years out. They stop, they go into default, there's a collection proceeding, and they say, my school did X, Y, or Z, and I'm asserting a defense. Well, it's 18 years since they graduated, right? So the idea would be that if the department looks back and says, well, you've paid $30,000 on this loan over the first 18 years, and you paid $5,000 of that in the first 5 years after you left the school, the department could still discharge the full amount of the loan. They could discharge anything the student hadn't paid, and they could pay back the student the $30,000 they've already paid on the loan. But they could only recover from the school the amounts that the student paid in the first 5 years during the recovery action. And the idea is it limits the school's exposure to a period of time during which they could have defended themselves, right? The problem here, and some of you I'm sure have already caught this, and what the department's going to raise is it puts the burden on the taxpayer. Because if the department discharges $30,000 and can only recover $5,000, that means the $25K is a loss, right, for the department and for the taxpayer. So it puts the burden on the taxpayer. But I would argue, if you want to give students the ability or borrowers the ability to assert a defense 18 years after they graduated, but you're telling schools not to keep any records they might need to defend themselves, which is sort of what's being said. Don't keep all those records and that data more than 3, 4, 5 years after the fact. Then you can't tag schools because they cannot defend themselves 18 years later. The people aren't going to be there. The records aren't going to be there. But you sort of accept as a school the idea that if the borrower is able to, successfully assert a claim that somebody did something wrong 18 years ago, and you have some exposure for that. And it's an attempt at a middle ground. This is just my recommendation, but trying to sort of thread this needle, if you will. All right, so it's top of the hour. We got 30 more minutes left. And we got plenty of time, by the way, because that was the bulk of what's really up for consideration. But I do want to go through financial responsibility and some of these other parts that are being discussed. And financial responsibility also is really important. So there was a lot of discussion in 2016. There's nothing about financial responsibility and the role, any of this that relates back to the 1993 borrower defense rule. But this really sort of all came up because the department was saying, well, one, we've got concerns about, schools and understanding when they're having financial challenges, et cetera, and that was the backdrop with Corinthian and some other big closures. But then in addition to that, and it's not, unfortunately, it's not just for-profit, nonprofit, across higher ed, as many of you know, in the last 4 or 5 years, there have been certain types of schools that have struggled. And again, that's not a matter of taxpayer status. It just has to do with sort of where higher ed in the world is right now. So the department's trying to understand when we've got financially distressed schools, how can we know? But there was also a thought that what if schools have lots of borrower defense claims? And how are we going to sort of work that into the financial responsibility? And that was how financial responsibility kind of got dragged into this whole rulemaking process in the first place. That having been said, the department has been thinking of it a little more broadly. So one of the things, and this was floated in 2016, and this was sort of recaptured and has been floated again here in this proposal, is that the department would provide what they'll call triggering events, right? And they give us 3 buckets of these triggering events. The first is mandatory triggering events. And I know the text is small here, but the important point here to make is they're really just a couple. Just a couple, right? If an institution incurs a liability from bar defense discharges or from a final judgment in an administrative or judicial proceeding, that's one. That's a trigger. Or for a proprietary institution whose composite score is already less than 1.5, if there's a withdrawal of owner's equity from the institution by any means, including by declaring a dividend, okay? Now, and I'm going to talk about this in a minute. I'm going to talk about what happens if one of these triggers occurs, right? But I just want to, all I want you to keep in mind right now is that's the first bucket, and these are just mandatory triggering events, right, for all schools, right? Now, keep in mind, of course, the second one there is just for proprietary, but this stuff about liability for bar discharges or a final judgment in administrative or judicial proceeding, that'd be any institution of higher education, okay? The second bucket is mandatory triggering events for publicly traded institutions. Those mainly relate to SEC actions or exchange actions. I'm not going to go through them, but if you're a publicly traded school and you're listening in, you know, you'll want to pay attention to those, obviously. And then the last bucket is what the department calls discretionary triggering events, right? And this is sort of a different list, and I'm going to talk to you about the difference in mandatory and discretionary in a second. But this includes, if you get a show cause order, that could lead to loss of accreditation. If you violate the security or loan agreement with a creditor, which for a lot of schools, private, nonprofit, for-profit alike, you got a lot of credit agreements floating around out there, right? If you violate a provision and that would enable the creditor to take some sort of action against the school, discretionary triggering event. If the institution violates a state agency requirement, which could lead to loss of authorization if they don't come into compliance. And then if a proprietary school fails to satisfy 9 or 10, or any school has 2 years of official CDRs that are over 30% or greater. Okay, that's your discretionary events. Now, these are both tighter lists, by the way. In 2016, the list of mandatory triggering events, they were sort of the same concept, but the list of mandatory events was longer and the list of discretionary events was much longer. And this administration said, look, we're trying to really focus on the mandatory triggering events on things that are quantifiable. Right, so you're talking about a number when you talk about discharges or judgments that will be on the paper, a real dollar amount, right? Or when you talk about owner's equity, a withdrawal of owner's equity. These aren't sort of speculative, these are real numbers that the department can latch on to. Okay, but what's the difference between a mandatory event, a discretionary event, and what happens if one of these triggers goes off? Okay, this is extremely important. An institution is only deemed to lack financial responsibility if the department determines that the event is likely to have a material adverse effect on the financial condition of the institution as a whole, right? So what the department has said here, and this is a significant difference from 2016, and for that matter, a significant improvement over current law. The department is basically saying if something happens, right, there needs to be a demonstration if one of these triggering events goes off that it has a material adverse effect on the institution. For those of you who aren't lawyer types, material adverse effect is a high standard. I mean, you're talking about something that, an existential threat, something that would potentially threaten the viability of the organization as a going concern, right? So that's the threshold. Not just that one of these events occurred, but that the event is likely to have a material adverse effect. So then the question becomes, what does that mean? How does this go? We know that's a really high threshold, and the department uses language in the preamble that talks about, you know, viability as a going concern, but there's still this sort of question of, well, how's the department going to determine if there's been a material adverse effect? Okay, so for those mandatory triggering events, right, so you got discharges, a judgment, or withdrawal of owner's equity. The department determines materiality by recalculating a composite score. And the idea is they're going to take your most recent composite score, your most recent financials, they're going to recalculate. They're probably going to show that stuff as expenses, right? And then, I'm not a CPA, but that's sort of the general idea. And they talk about in the proposed rule in a little more detail how they would calculate it into the composite score. But basically, you know, it shows up as an expense. And the idea is, will it take your composite score below 1? That's the threshold. Now, they don't do the recalculation of the composite score for the publicly traded mandatory triggering events. So again, if you're a publicly traded school, if you hit one of those special triggers, that is just considered in and of itself to be a material adverse effect if that thing occurs. And you may want to talk to the department about that in comments, right? But for those other mandatory triggering events, there's an evaluation and a recalculation of the composite score. Now, there's some confusion out there. Is this a new official composite score? Do you have to give this to other entities, you know, or is it strictly recalculated for the purpose of determining materiality? And then there's a question of, well, what if you have 2 or 3 triggering events in short order? I mean, what if you're like in 2 or 3 lawsuits, or you've got several borrower defense claims over 6 months? I mean, are they all put together and you get recalculated once, or does that mean the department's recalculating on 6 separate occasions? There's a real lack of clarity. But what's important for us to latch on here, I think, at a slightly higher level, and you're welcome to get into the weeds and comment on all of that, but at the higher level, the important thing is the department is not proposing that a trigger, one of these events occurring, would automatically lead to a determination of a lack of financial responsibility and a requirement that you post a surety. And once upon a time, the prior administration suggested something along those lines. This department is saying, we want to know if this stuff happens, and if it happens, we're going to have a discussion about whether or not it really is going to have an impact on your institution. And that is good for schools, because there's been a lack of clarity in the past and even in current law around what happens when you have some sort of event. How do you have a conversation with the department? Can the department just hit you with a letter of credit? Is there a back and forth? And what this rule is proposing is a framework for a discussion and a threshold, and that's really good for schools. Right? For discretionary triggering events, the department would work with the institution and the accreditor to determine whether that action has or will have a material adverse effect. Now that sounds a little squishy. Rest assured, there's a little more structure in the actual rule. So the proposed rule guarantees in the regulatory language, not in the commentary, in the regulatory language, that institutions will have an opportunity to demonstrate that an event has been resolved, demonstrate insurance covering associated liabilities, or, quote, explain or provide information about the conditions or circumstances that precipitated that triggering event that demonstrate that it has not or will not have a material adverse effect. This is a great, great opportunity for schools, right? The department also contemplates submission of mitigating information in specific instances regarding certain specific triggers. For example, if you could document that that withdrawal of owner's equity was used exclusively to meet tax liabilities, or that the creditor waived the violation of the loan agreement. So in my view, this is all very positive. And I would strongly suggest that folks support this type of proposed rule with some of these other caveats, you know, maybe more detail around the recalculation of the composite score. The one thing I want to highlight for schools that I think schools should comment on is that the department, for reporting, the department says, well, look, you know, you got all these triggering events, so you've got to report it to us. That's part of the idea here, is so we can have that conversation. And you've got typically 10 days to report the event. The one that concerns me is that the department is requiring that you report every liability arising for a judicial or administrative action. So there's no materiality notion here. And what do you mean, Erin? Why is this a problem for us? So for you all that are on the phone, the university, the state universities, by the way, showing that you're financially responsible if you are a public institution is a little easier. You just need essentially a letter from the state, right? But that doesn't absolve you from what I can tell from these reporting requirements, and maybe that's a question you want clarity on. But even for there's no question that the large private nonprofits on the phone, you know, are subject to this rule. And what this means is every time you have an administrative or judicial decision, you're going to have to report it to the department. Well, how many slip and falls do you have every year, right? I mean, how many, because there's no allowance for any, it doesn't say judicial judgments that only relate to borrower defense claims. It doesn't say judicial actions that may exceed some level of material. It just says every single one. And the department, we objected to this during the rulemaking, and the department says in the commentary, they sort of say, well, you know, we just think we need to know about all of them. But I really encourage the big schools out there to think about how frequently you would be reporting some sort of judgment to the department. And here's the other thing, and I'm not sure the feds have thought through this. There's nothing that suggests that they will take into account the materiality of the judgment before recalculating the composite score. The way the law works, it just says you have to report it, and then they have to recalculate the composite score. Does that really mean the Department of Education is going to recalculate a small claims court decision against an institution for, you know, $800? You're going to recalculate the composite score for the school? It seems a little out of whack to me. And I would encourage schools. I think overall this framework is really positive for institutions in many ways. But I would try to get the department to buy into this idea that having us report every single judicial action for a large private nonprofit does not make any sense. That's just going to create headaches for the schools and headaches for the Department of Ed. There ought to be some way, and we had suggested, you know, if your auditor considers the judgment beyond a certain threshold, if it would be material to your CPA or something like that, you know. But I encourage you to think about this one. Okay. The other couple of things that showed up in the financial responsibility section that I want to hit on briefly, one is the treatment of long-term leases in the composite score. So I'll just hit this and move on, but as many of you know, if you're a CPA or some of you know, if you don't know about this, you need to find out about it. Especially if you're with a smaller school and you haven't thought about this, there's a change in the treatment. FASB, which is the board that governs how accounting is done, right, and the accounting standards, there was a change that they announced a little while back, and it's about to go into effect, right? And the department acknowledged in the commentary, there's a quote from the department, that the change to the treatment of long-term leases is a significant change in the FASB standards and one that could have a dramatic impact on an institution's composite score, even if the financial condition of the institution is not changed. And the short of it is, the change requires going forward, again, I'm not an accountant, so you're getting the lawyer's summary, but the idea is that going forward, schools are going to have to include long-term lease obligations as an expense on their balance sheet, whereas right now, in most cases, they're off the balance sheet, and that's going to impact your composite score, right? So the department has proposed that upon request, and this was going to be a big concern, because if there was no accommodation for this, you could literally have a school that had a 2.1 composite score, and just overnight, because the standard changed, suddenly had a composite score that dropped 0.3 or 0.4, depending on what kind of situation they might have with leases. So the department has said, look, upon request, what we're proposing is that we'll compute a second composite score, which will exclude operating leases sort of under the current standard, and we'll use the higher of the two. So to be clear, they're saying on a go-forward basis for a period of time, we'll just do two. We'll do one using the old rule and one using the new rule, and we'll give you the benefit of the higher one, right? They propose to do that for the next 6 years, or until a revised composite score regulation is promulgated, because the department is also suggesting that they want to initiate a new rulemaking and overhaul the composite score in a more comprehensive way. The idea of a transition period is great, and I would suggest that schools want to strongly take advantage of this and support this idea. But one thing you might want to do is say, hey, department, that being said, why don't you just give us a guaranteed 6 years? As opposed to saying, well, 6 years or until the composite score gets redone. Because the problem is that creates uncertainty. What's interesting is the department's whole basis for giving you 6 years is, this creates uncertainty for schools and blah, 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 and they need to be able to plan. But then they sort of throw in this uncertainty by saying, so you'll have it for a one-time frame or another, depending on how quickly you get a new rule made. It seems like it would be much easier for the department to just say, for 6 years, we're going to do it this way. Certainly, that's better for schools because you get some certainty. So I would recommend that you support but ask for a fixed 6-year transition period. The other thing I want to mention very briefly is the treatment of long-term debt in the composite score. So right now, there are schools out there in all sectors, some of whom are using certain forms of long-term debt to manage the composite score, right? Manage is the nice way of saying it. The department in the commentary uses the word manipulate. I'm not willing to go that far, but look, schools for a long time, some schools out there, again, in all sectors, I know of schools in, for-profit, non-profit alike who've done this. And so what the department would require, and this is just in a note to how the composite score would be calculated, but they've thrown this in here. They are saying that to include debt as a part of the total debt obtained for long-term purposes, including through long-term lines of credit, a school would have to provide a disclosure in the financial statements that the debt, including that line of credit, exceeds 12 months and was used to fund capitalized assets, PP&E, et cetera, right? So the idea here is they're really trying to close this loophole of schools using long-term lines of credit to infuse capital into the institution and boost the composite score, right? I think that's really what they're getting at, but they've even gone a little broader here, and they're getting after all forms of long-term debt. I'm not making a recommendation on this. Again, depending on your point of view, some folks would feel like that's really not an appropriate thing to be doing. Others might say, well, if you can secure long-term debt or a line of credit, isn't that a show of financial wherewithal? I get both sides of the argument. Mainly what I want to do is highlight for you, if you're a school that is doing this, you need to be thinking about this because this could be a big change for you. Okay, closed school discharge. This was a real shocker. I think this landed in a really positive way for schools. And I will tell you, we've only got 9 minutes left, so I can't go into great detail. But I've never been happy with the way closed school discharge works. And one thing I want to make sure everyone on the phone understands is we're not just talking about a situation where an entire school closes. We're talking about any time you close a single location, an additional location, that the closed school loan charge regs apply. So if you're a private nonprofit with 37 locations at military bases in the U.S. and around the world, every time you close a location, these regs apply. Keep that in mind, right? So this was sort of a mixed bag on closed school discharge. So what the department did was they want to extend the period that applies for students. Right now under the rule, anyone who withdrew within 120 days of that location's last day of instruction under the current rule typically would be eligible for a loan discharge. The department wants to extend that back to 180 days. And let me tell you how it works in a practical way. When you have a school or a location that shuts down, the department says, tell us everyone who was enrolled and withdrew within the last 120 days, and then they just send all those people a closed school loan discharge application, right? I strongly disagree not only with expanding to 180 days, but with the very idea of using a time frame. Because what the statute says is, if someone can't complete their program because the school closed, they should get a closed school loan discharge. It's not about when they withdrew, it's about why they withdrew, right? So if someone withdrew a month before you closed, but they said they withdrew because they wanted to go to Hollywood and be an actor, they shouldn't get a closed school loan discharge. They weren't unable to complete their program because you closed, they withdrew because they went to Hollywood, right? On the other hand, if you announce you're going to withdraw or you're going to close your school 6 months out or 8 months out or whatever, and you're not going to finish the program out for someone who might be in a 4-year program and they can't complete their program as a consequence, why wouldn't they be eligible for a closed loan discharge? But tying it to a time frame, a random or arbitrary time frame, as opposed to the basis for the withdrawal makes no sense, and I think is a departure from the statute, and I don't support it. The two things that are great here that the department is offering up, one is there are certain bases upon which the department already under the law can extend that time frame beyond 120 days, and they've tightened that up. They've said, you know, they've shortened that list, and I think that's positive for schools because I think the list is more consistent with the spirit of the statute. But the other thing that is huge, under current law, if you're closing a location and you provide for a teach-out, you get a teach-out partner, et cetera, that's going to teach the rest of the program so the student can complete their program. Doesn't matter. Doesn't matter. If they withdraw within 120 days, doesn't matter if you provided for a teach-out. They could even participate in the teach-out, but if they don't complete the program because of the teach-out, they are eligible for a closed school loan discharge, right? And we've argued for years that that doesn't make any sense, right, because they could have completed the program. And again, that's the whole point of the statute. If they can complete the program, they shouldn't be eligible. The department, shockingly, because in neg reg they were not interested in this from my standpoint, in this proposed rule they have said they've got a new safe harbor, and they say if you're closing a location and you set up a teach-out opportunity, a student is not eligible for a closed school loan discharge, right? That is a tremendous safe harbor for schools. I think it properly incentivizes schools to set up meaningful teach-out opportunities. I think it's great for institutions because it gives them a way to close locations without being exposed to closed school loan discharge liability. So I cannot encourage you enough to write in a comment supporting the closed school loan discharge safe harbor for institutions that have teach-out. Okay, false certification. Right now, as you may know, there are certain circumstances pursuant to which the department can discharge a student's loan if they deem that the school falsely certified the loan. And there are 3 or 4 different things that go into that bucket. If you don't know what those are, by the way, and you're a compliance officer and an attorney, you ought to look them up because you might be surprised by a few of them. But one of the things that's not there in the current law is if the student didn't really have a high school diploma. Surprisingly, there's some language about ATB, ability to benefit, but there's nothing that just says if you certified the loan and the student didn't actually have a high school diploma or its equivalent, then that's a false certification discharge. So the department in part wanted to update that language. And one of the things we pointed out, though, is we said, well, wait a minute. If a student represents to a school that he or she has a high school diploma and the school relies on that, that shouldn't be a false certification discharge because the school didn't do anything that was false. They were relying on this attestation of the student. And again, during the negotiated rulemaking, this didn't seem to get a lot of traction, but it showed up in the proposed rule. We were very pleased, and I think this is also something that's really important to support. But unfortunately, the exact language that the department has proposed is a little clumsy. And it requires, you know, that not only did the student, you know, represent to the school that they had a high school diploma, but also that certain other particular prerequisite conditions were in place. And I think it's really just confusing, in addition to sort of undermining the value of the carve-out or the safe harbor. So we proposed alternative language. I've included it here if you want to use it. And it just simplifies this idea. It just says, look, they don't qualify for a false certification discharge if they attested to the school in writing and under penalty of perjury that the borrower has a high school diploma or completed high school through homeschooling. And this would cover you in either case. And if you don't have one, what I would suggest is you put together an attestation separate from your enrollment agreement or anything else that folks sign during orientation that just says, and separate from the FAFSA, that just says, I certify that I've got a high school diploma or completed homeschooling. And then, you know, maybe under your policy you actually require a transcript in advance. But you're going to have students occasionally say, I can't get a transcript, school burned down, or I was homeschooled, and you still want to have that attestation document, I think. And finally, the department is not prohibiting pre-dispute arbitration agreements or class action waivers. They acknowledged during negotiated rulemaking very openly, they said we consulted with the Department of Justice and others based on various recent Supreme Court rulings and other things. We do not think we have the ability to try to outlaw or prohibit these types of pre-dispute arbitration clauses or class action waivers, either in enrollment agreements with students or any other agreement with students. And some of the nonprofits out there may think we don't use enrollment agreements, but it's worth checking. You know, you might have agreements for use of athletic facilities or parking garages or other things where it's an agreement with the student that has a pre-dispute arbitration provision. The department said, you know what, we agree we can't cover that. They have said, instead, we're going to require enhanced disclosure during entrance counseling, et cetera. You know, I don't think this is bad. It may create some burden on schools, and I know some of the financial aid folks didn't like it. From a lawyer's perspective, the number one argument that a borrower or student is going to make if they're trying to defeat one of these arbitration clauses is that they didn't know about it or it wasn't adequately disclosed, right? So if the department requires you to more adequately disclose it, I mean, it's essentially strengthening your ability as an institution to enforce your own pre-dispute arbitration clause. That's not a bad thing. I appreciate it may create a burden on the front end, an administrative burden, but it probably makes your arbitration and class action waiver stronger. So we don't oppose that, and we would suggest, in fact, supporting the rule. Real quickly, I just want to hit on a couple of things. I know I always put up the TC resources, but we actually have a higher education webinar series that is beginning this month, and it's going to run sort of consistent with the academic year all the way through next summer. These are all free. They will all be CLE certified. I'm hosting them. We've got various other attorneys. If you're interested, if you're one of those folks who listens into a lot of our webinars, would love for you to sign up. You can email my producer, Erin Lacey. You can see at the bottom her email address, and we'll make sure you get registration links when they come around. But we'd just be delighted for you to be a part of this. We've gotten a lot of great feedback on our webinars. It is a great way for us to reach out to our client base and also just higher ed in general. And so we thought this year we would do sort of a formal series, and we're really pleased to be offering this up and hope you'll join us. Also, just a reminder, all of our webinars, including the ones we're doing on the higher webinar series and including this one today, are all sitting on demand on our TCLE website. And you can even see upper left-hand corner, notice of approved rulemaking. So that's today's, and as soon as it's available, that's where it'll pop up, and it'll say view recording. Finally, we do still have our Regulation blog, where we also write about a lot of different things, and hope you'll check us out there as well. So with all of that having been said, I will now make an attempt to move on to and maybe answer some questions. Doesn't including either of the words misleading or deceptive in the definition of misrepresentation expand the definition beyond factual issues and make it very elastic for complainants? Yeah, interesting question. I mean, that might be one we'd have to think about on the side. Let's see, extend that beyond factual issues. I mean, I think the department has always intended that if you, through act or omission, mislead someone, and and they talk about in that definition that relates to affirmative claims, it's not just a misrepresentation of fact, but of opinion, of circumstance. I mean, and if you look at the examples of evidence of misrepresentation, I don't think it was ever the department's intention that the misrepresentation was limited to factual issues. I mean, I do think that it could already extend beyond factual issues. But look, you know what? If you have thoughts that that definition could be improved, I would encourage folks to comment on it. Let's see. Are students in schools allowed to be represented by legal counsel in this process? I'm not aware of anything that would prohibit an institution from, well, let me take this in two parts. So first, you've got the discharge proceeding, right? I don't know of anything that would prohibit, there's certainly nothing in the reg. I don't know of anything that would prohibit a school from utilizing legal counsel. And in fact, you know, one of the things that we do regularly is represent schools in program reviews and audit proceedings and Subpart G proceedings. And so I think the department is very, not only is it allowed, but sort of anticipates that schools will regularly use counsel in these processes. Although the discharge process, as it currently stands, it doesn't afford or create an opportunity for an in-person hearing. It's all on paper. So, you know, if your attorney was representing you, they could be assisting you to write and draft things and evaluate, but you could still just put it in under the school's name. The Subpart G proceeding, the recovery action, absolutely anticipates the counsel will be involved. And in fact, the changes that happened in January 2017 really took that Subpart G proceeding even further towards looking like good old-fashioned litigation. I mean, it contemplates motion practice, expert witnesses. There is every anticipation that in a recovery action, institutions would potentially be represented by counsel. And I will just throw in, that's part of what we do. So not just for the person who asked that question, but for anyone, you know, honestly, I would expect, and we would be delighted, certainly, although I hope nobody ends up there, but to work with schools if they are in a Subpart G proceeding or even sooner. And in fact, I would recommend, whether it's us or someone else, that if you're dealing with a bar defense claim and you've got regulatory counsel that deals with the Department of Ed, I would certainly consult them right away. Shouldn't commentators suggest ALJs be used for administrative law judges, be used for student claims to avoid, this says a mom administration or any, you know, any staffer or administration that might be, you know, less favorable towards institutions from hearing their claims. You know, I consistently advocated from a pretty early point that, first of all, I advocated for a single process, that there shouldn't be some sort of discharge process and then a subsequent recovery action. I said, you know, it should be one process and it should be in front of an ALJ and it should have all the due process trappings. It doesn't make sense to me that, you know, you've got two different people evaluating this potentially under two different standards. I think it creates problems for taxpayers, et cetera. And you guys, if anyone listened to my debriefing webinars on bar defense back in the first part of this year, I made that point. The department has and seems, including this administration, committed to having a two-part process and to permitting the first part to be carried out by staff. There is, I think, really good and reasonable concern that staffers, and I made this point earlier today, right, will be subject potentially to political pressures. The department says, well, it's too expensive and we can't go, everything can't go through an ALJ process. I don't know why you could not hire and train a group of ALJs, you know, 2 or 3, specifically to perform this function. And to not under Subpart G, but under, you know, this, it would be this sort of streamlined discharge process, but it would be handled by an ALJ. And that's all they would do. You'd have 2 or 3 that would manage, just like you got small claims court judges and, you know, judges in all over the place to do certain types of things. I agree with you. I don't know why that's not feasible. And I think as schools wanted to continue to push that, you know, rather than staffers do this, that there's, in the process, there should be a reg that requires that this be in front of an ALJ. Doesn't have to be, again, under Subpart G. It could be under this process, but just that an administrative law judge should be handling it within the Office of Hearing Appeals. You know, I don't disagree with that, because I agree. I have a real concern that staffers will be potentially subject to political pressures. See, at one point, schools had to post some sort of line of credit for each claim. Will that still be in place? So I think this is referring to the idea that once upon a time, in the proposed 2016 rule, there were these triggers. We're under financial responsibility here. And if a school hit one of the triggers, they automatically had to post a letter of credit, and the letters of credit were stackable. So if you had 3 triggers, you had to post 3 letters of credit, right? That actually was thrown out even in the final version of the 2016 rule, and it's not on the table here. every type of trigger, whether mandatory or discretionary, still leads to a conversation with the department. It's mandatory, it involves a recalculation of the composite score. But there's still a conversation where a school can show the insurance or that it's gone away or try to establish it's otherwise not really a material adverse effect, right? So that's really important. Not only is there no stackable letters of credit, there's not even an automatic letter of credit or surety concept, right? Everything first has to go through a conversation with the department. Let's see, what is the definition of long-term lease? You're going to have to call your CPA on that. I mean, I have a couple of thoughts, but I'm not certified to speak to that point. Apologies. If the borrower receives 100% discharge, the school can refuse to verify or provide an official transcript. Does the institution have this option for less than a 100% discharge? That's a great question. Well, I think it's going to depend on your institutional policy, right? So if you have an institutional policy that says if you have an amount outstanding, you don't get your transcript, and that's, you know, under your policy, I'm not sure why it would take 100% discharge, right? I mean, if the student owed you $80,000 and department discharges $40,000, that's a pretty big chunk of change that's outstanding. So maybe one of the things we should be recommending here, or schools should be recommending, is that disclaimer in the, remember that was in the claim form, maybe what it should say is if the discharge results in any amount outstanding to the institution, that the student, you know, may not be able to continue to access their transcript. That's a great question. All right, well, that's all the questions and answers. Again, we'll be sending out a registration link really soon for our first installment of our higher ed webinar series, which is going to deal with student litigation. And really hope folks will join us for that. And thank you all again for tuning in. And please fill out those evaluation forms. Talk to you soon. Bye.